All right, let's talk about the judicial system. This is our court system, one of the three branches of the government. We have the executive branch, the legislative branch. We've talked about executive orders, they come from the executive branch. We talk about statutory laws, they come from the legislators, the legislative branch. And now we talk about the judicial system, who kind of keeps those two things in check, the checks and balances. So how our judicial system works. We have a federal judicial system and we have a state judicial system, plus DC has their own federal and state system. And then we have the United States Supreme Court, which usually gets lumped up with the federal system, but they do oversee or can hear cases out of state court as well. These court systems operate independently of each other. So that means that, the federal, what it doesn't mean is the federal system doesn't get to trump what the state does. They work independently of each other. And this is right now a little overview. We'll get into the specifics as we go along. And generally each system, both in the federal and in the state, operate or are structured like this. They're divided in two distinct courts. They have a low-level court or a trial court, and they hear the case. They're going to hear everything. They're going to hear all the facts of the case, and they're going to hear all the law of the case, involved in the case. And the appellate court, which is the next step up, will hear only the law of the particular case. And I'll go into this in more detail. This is just general. The facts in a certain particular case are what happened in this case, what the court or the jury has to listen to make its decision. And the law is what should be done because of those facts. And a law pertains to a specific circumstances or a specific factual pattern that's before the court. All right, enough with the general discussion. Let's jump in and take a look with the state system. Let's start with the state system. This is generally how a state system is structured. Like I said, there's 50 states. Each state and DC have their own court system. They all have to have at least a lower court and appellate court, okay? Which are, according to my little diagram, are kind of the two in the middle. A lot of states have a traffic or a municipal court where that hears low-level type cases, traffic cases, and small claims. We won't be dealing with that kind of court. That doesn't happen. Trademarks, patents, copyrights don't happen in that court. And then there's a court that's the lower court. It's usually identified as a superior court. I know that's the case in Vermont, Connecticut, Massachusetts, and a number of other cases. That is not the case in New York. I'll show you the New York system in a second. But this is the trial court. This would be the court that hears the facts and the law. And then generally the appellate court is called the Supreme Court of Massachusetts, or the Massachusetts Supreme Court, Connecticut Supreme Court, and so forth as their appellate court. And that is the highest court in that state. And depending on the type of case and the type of issues involved, the Supreme Court might take a case or hear the case. And I'll explain when they do when we talk about the Supreme Court. So, Superior Court, or lower court, is a court, as they call it, of general jurisdiction. Now let's talk about that fancy word, jurisdiction. What that means is a court's authority to hear a case. A court can only hear a case within its area or jurisdiction. So if we're talking about the court here in Plattsburgh, which is called the Supreme, our lower court is actually called the Supreme Court. I know it's going to be confusing, but let me just use my slide from before. So let's say the lower court is called the Superior Court, like it is in Connecticut or Vermont. That court has jurisdiction to hear any case in the state of Connecticut or in Vermont. Certainly the jurisdiction can be narrowed based on county or the location of the court itself. But if I'm in Connecticut and I'm in, let's say, Stamford, Connecticut, which is down towards the tail end of Connecticut, going towards New York or New York City, and I'm involved in a civil case, let's say it's a trademark dispute within the state bounds, I can bring my case in Hartford, Connecticut, which is more up and centrally located, because it's in the state of Connecticut. They both have jurisdiction. If both of the parties are located in Stamford and there's a court in Stamford, it would be wise just to go there for convenience purposes. But generally, a superior court governs their jurisdiction, which means their state, their kind of state area. And when I show you the New York map, I'll use Plattsburgh as an example a little later. So they are the court that hears things first, the lower court. And when I say hears things first, this is where everything's found. This is where the paperwork gets filed. This is where the jury's found. This is where all of the facts are going to come into play. Trademark can come in here, a trademark dispute if it's just a business, if we're dealing with two businesses in one state. We're not talking about like Coca-Cola, because they operate worldwide. And I know we haven't gotten there yet, but for purposes of this example, this court would hear that kind of case. It would hear a trade secret kind of case. It'd be hard-pressed to hear a copyright case, but if there is a very old, let's say, and when we talk about music, it'll make a little bit more sense of why it landed in state court and not federal court. But if we're talking about some music from the early 60s, prior to some changes in 1976 to the copyright law, which we'll talk about, the only recourse for sound recordings was to go to state court and hash them out. And there's a lot of those kinds of cases in state court, and we're going to talk about them. For purposes of this discussion, you have to know that there's always a lower court and an appellate court within a state, and the lower court is the case that hears everything first. They create the case. They create the record, so to speak. If you've ever been in a courtroom, there's a person that's taking down everything, the court reporter or the stenographer. What she's taking down is everything that's happening in that courtroom. She's the one that takes in all the evidence. So let's say there was a case over the last several years involving Spirit and Led Zeppelin. That was actually a state court case in California, I believe it was out of. The band Spirit sued Led Zeppelin because they claim that Led Zeppelin infringed on their song, which the name of the song escapes me at the moment, but what they're saying was Stairway to Heaven, that they stole their riff in their music and incorporated in the Stairway to Heaven. And in that trial, there was experts who had to come and talk about the musical composition. The sheet music was entered into evidence. All of the band members testified, because one of the things you have to prove in a copyright infringement case is access, whether or not Jimmy Page had access to the song. And the song was released on an album, and Spirit had also played as an opening act for Led Zeppelin at one point. So all of those things, the experts who testified, the sheet music going in, and the members of the band, that's all facts. That's how the facts are created. And all of that gets transcribed and given to the court reporter. And then from there, the judge or the jury, the judge gives, if there's a jury, which there was in the Led Zeppelin case, the judge will give the jury the instructions or the law. This is the law that we're dealing with in this case, and what you heard, all of those facts, you have to apply to this law. If you think this law applies and Led Zeppelin did A, B, and C, then you have to find them liable. You have to find them responsible. They don't find them guilty. It's not a criminal case. You find them responsible or liable. So and then money damages are paid out. So that's how the lower court works. Now, what also happened in that case was that Spirit lost. Led Zeppelin won. So the plaintiff who brought the case, who claimed that Led Zeppelin infringed, appealed. And where did they appeal to? The Supreme Court, or the state's highest court, the appellate court. It's usually, like I said, the highest court in the state. It's also the final authority on state law. It won't rehear the case. It won't say, oh, hey, bring in those witnesses or anything. They will not hear anything new. Oh, wait, we forgot this. No, none of that comes in. It has to, it reviews the record that court reporter took down or that was established in the lower court. And it reviews the law that the judge was given to the jury and how the jury applied it to those facts to determine whether or not it was done accurately. Okay, what the Supreme Court or the appellate court is not looking for is to say, yeah, the jury got that all wrong. This is how we would have decided. That's not what they do. They decided whether or not there's any errors that were made by the judge. Oh, the judge gave this wrong ruling, so the jury heard this. Or, oh, the judge left this out and it should have come in, and if it would have come in, the jury could have decided differently. They look for mistakes that happened. So from here, I said earlier that the United States Supreme Court can hear an appeal out of the state court, but it would only take a case out of the Supreme Court or out of a state court if the issue involved what we call a federal question. And something that's a federal question results in that was unconstitutional. It's against the Constitution. That's a federal question. Otherwise, they're not going to take the case. They won't have quote-unquote jurisdiction. It has to be a federal issue or question for them to decide. And I'll talk about that fancy little word writ of certiorari when we get to the Supreme Court. So this is the New York State system. A little bit more complex than the 4 hierarchy I gave you a little earlier, and just to kind of give you an idea of how this court system works. We will not be dealing with anything in the bottom gray line, but I'll work through them from left to right. The New York City Civil Court, that's kind of their small New York City's civil court for small claims, small commercial actions, maybe evictions fall in that category. I think they have a separate housing unit of that. New York City's criminal court only hears criminal cases, low-level criminal cases, misdemeanors, traffics, that sort of thing. District courts are the Long Island criminal courts. They have them divided into districts that hear low-level criminal cases, traffic infractions, ordinance violations and things. City courts, this is up from here on, is upstate. We have town courts, village courts, city courts. They are the low-level municipal courts, traffic courts. They hear the lower-level crime-type cases, small claims, things of that nature. Court of claims, back to the left-hand side, that's if you're suing the state of New York. That's where you bring your case if you want to sue the state of New York or one of its agencies. The small blue to the right, surrogates court, is our probate court, deals with guardianships. County court is our felony criminal court. All felony criminal cases happen there. And then family court has all the family court cases. Custody, child support, things like that. Now, Supreme Court, right dead center, is our lower court that I've been talking about. So if there was a copyright infringement case that had to be brought in a state court in New York, it would be brought in Supreme Court. And our Supreme Courts are established in, I'd say counties. There's a judge in every county or assigned to every county, but that doesn't mean you have to bring it in that county. You can bring it anywhere in the state. If somebody wants to challenge the court's, quote unquote, let's say venue, because it's more convenient to be someplace else, that's different. But any of Supreme Courts has jurisdiction, general jurisdiction, to hear a case within the state of New York. Now we have, from there, everything gets appealed up to the appellate division. That's the first bite of the apple appeals court that we have here in New York. In most states it would stop here, but we have another level. Well, let me stay with this appellate division where it says 1, 2, 3, 4. This appellate court, which is what you would appeal your copyright case from the Supreme Court to, is divided in divisions. We're in the 3rd department if you're sitting in Plattsburgh. That's north of Albany. I'm trying to think, Washington County area. The North Country mostly is in the 3rd department. 4th department is the, I think it's Oneida County, out towards the western part of the state. And Oneida County is the Utica area and out. And then 1 and 2 are Long Island and Westchester County, New York City, that area. So our appellate division is divided into 4 divisions. And then we have one more jump to the Court of Appeals. It's not a freebie. You can't keep going. You only have one bite at the appeals apple at the appellate division. You have to ask for permission to go to the Court of Appeals, and the only way a Court of Appeals is going to hear the case is if there's an issue violating our New York State Constitution relative to the laws. Like this law violates our rights under the New York Constitution, or there's these courts are divided on a particular issue. But that's extremely rare. They hear fewer cases in the other appellate court. So that's the New York State system, or that is the New York State system, and that finishes our discussion on the state systems as a whole. So let's move on to the federal court system, which is the system we're going to see a lot more of the copyright cases in. So we're going to go through this, and I'm going to go through the Supreme Court in great detail because the Supreme Court is the authority on the federal law and where we're going to see most of the cases we talk about. So our U.S. Constitution calls for one single court, the Supreme Court. But the Constitution also allows Congress to create or abolish federal courts. So as we know, Congress has created, because I'm telling you, a system of courts to complement the Supreme Court. So the Supreme Court doesn't get overwhelmed with all of these cases in the country. And you'll see that despite the fact that the United States Supreme Court can hear just about anything, they are extremely limited in what they hear. So the federal court system, each of the 50 states has a federal court system, and the District of Columbia. And they also have the same hierarchy. We have a lower court that hears everything, and then there's an appeals court, first crack at the appeals court, and then there's a request that you can get to if you want the Supreme Court to review the case as well. And with district courts, the smaller states have this setup where they have a district court and then they go to a court of appeals and then possibly the Supreme Court. But in bigger states, the district courts are divided and they can have more than one. New York has more than one. We have the Northern District of New York, we have the Southern, Western, and Eastern District of New York, and as you can imagine, it's divided just like it is. We're sitting in the Northern District. Anything north of Albany out to Syracuse actually is the Northern District. The Western is Buffalo, Rochester, actually out to Syracuse, Rochester, and then Southern is the Long Island area. Eastern they consider is New York City. That's how the Eastern Southern, I think, the Southern is actually located in New York City. So I'm mostly familiar with the Northern District and the Western District. Those are the two areas, the two federal courts systems that I've worked in, and in Connecticut federal court. So this is our United States federal court system and how it's broken down. There's obviously they have other little components. What we're looking at is to the left-hand side. That's what we're going to be concerned with, not the U.S. tax court. even though that's its own court in and of itself. There's one in each jurisdiction. We are dealing with the U.S. district courts. That's our lower courts. They're the ones that hear the facts of the case. The Court of Appeals is the appeals court that's going to hear any appeals out of the U.S. District Court. And you'll note it says there's 12 geographic circuits. And you might be thinking, well, then aren't there 50 states? Shouldn't there be 50 Court of Appeals? The Court of Appeals system, the U.S. Court of Appeals system is they clumped states together in each of its appeals section. So the Second Circuit holds New York, Connecticut, and Vermont. So if there's an appeal on the Northern District Federal Court, it's going to go to the Second Circuit. Any decision the Second Circuit makes is going to affect the laws in New York, Vermont, and Connecticut, because those are the states that are under its umbrella. So they're each groups of states are in a particular geographic circuit. And then there's the Supreme Court. So what types of cases do the federal courts hear? They actually hear 7 different types. We are only concerned with 3. Cases that arise under the U.S. Constitution. Cases involving controversies when the United States is a party to the case. And number 3, cases involving controversies between citizens of different states, and the amount sought is over $75,000. Now the last one is the one that's probably going to bring us most of the cases for copyright law. We're dealing with people or citizens, they're from different states, and they're looking for well more than over $75,000. Cases involving controversies when the United States is a party. Generally, that's a criminal kind of case, government versus Smith. I may bring up a few because you can be arrested for copyright infringement. If you guys have ever seen, the beginnings of movies that said, do not copy, FBI warning, do not copy. I'll show you the law. And cases that arise under the U.S. Constitution, we're going to see some arguments there. First Amendment rights usually, right to free speech and a right to free press. We see those relative to copyright infringement. When is it fair? It's kind of lumped up with the fair use argument. If you are the press, you're trying to report on a work or something, you should or certainly want to be able to, look at, this painting here, and you're putting it on your news story. Is that free speech, free press? Is it something else? It's certainly fair to use in that context. But there's some arguments that arise of whether or not a use can be unconstitutional or not. So we might visit some of that, but most of them are going to fall under number 3. So let's talk about the Supreme Court. The United States Supreme Court is made up of 9 justices, and this was established by Congress. Congress didn't say in the Constitution there has to be 9 justices. Actually, there's been 5, there's been 6, there's been 7, there's been 12, I think, over the last, 60, 70 years, it's been 9. I think 9 is what it is. That's what Congress has established it to be. Now, if we were in a classroom, I'd have you name all 9, but there's a link to the Supreme Court's website on Moodle, so I suggest you can check it out and see who our justices are. These are the folks that decide the very tough decisions in our country, and then they become our law. The Constitution gave this court, like I said just a moment ago, original jurisdiction, which means they can hear everything under the sun that comes their way. But it was Congress who gave them their appellate jurisdiction, and that is what they mostly hear. They mostly hear appeals that come from the federal court system, but like I said, they do hear them from the state courts too. So there we go. So how do they hear a case? I said it's extremely hard to get a case heard by the Supreme Court, and they get near 7,000, just over 7,000. At least last year they got over, according to their website, they got over 7,000 requests or petitions for them to take a case, they took 106. So that's how hard it is to have your case heard by the Supreme Court, or a case heard by the Supreme Court. And like I said, there could be a direct appeal that comes right from a federal circuit court involving a federal question or a violation of the Constitution. Federal question can also involve a review of a federal law. Remember from the last slide regarding statutory law, they have to interpret the statute, determine what it says. That federal courts would review the federal statutes, but the court can merely reject it and say, no, that's too trivial for us. That's one way. But the most popular way is the second way, writ of certiorari, or writ of cert, as they call it for short. It's the most popular view, and it's what it is you're asking the court to give you a discretionary order to then pass along to the lower court or the court just before it to send them the record. Okay? Where does the case come from? It could come from the federal appeals court or the state appeals court. And so how do you get a writ? The party who wants the court to hear the case must be the one to request it. They have to request it. What they do is they file a petition, and they have to show, one, that they have exhausted all their legal remedies. What that means is they have went all the way up the ladder of court systems for a decision. There's nowhere else to go. They must present an important legal federal question. If it doesn't, it's not even going to be considered. It's going to get kicked out right then and there. The review process, all 9 judges actually are involved with the review. 4 of them must think the issue has merit. You only need 4 of them to say, hey, let's take this case, the rule of 4. You only have to convince 4. The types of cases that they will hear, they usually take, is if there is a split decision in lower courts. And what do I mean by that is that, as I said, there's 12 circuit courts, appeals courts in the federal system, and they can decide based on their interpretation of the federal law what they feel it is. And that can be different in California, the Ninth Circuit, than it does in the Second Circuit where New York sits. And I bring those two up because California and New York are our biggest states where the entertainment industry lies most of the time. So we're going to see a lot of cases out of the Ninth Circuit and out of the Second Circuit, and you're going to see that they are different when you have the same sort of facts. I'm actually going to have you guys later in the semester, after we've learned some copyright law, to review 2 of cases based on the same facts but different jurisdictions. So that's one that they'll hear. Important federal question. Like I said, it could be a constitutional issue, a violation of the Constitution. It could be an interpretation of a federal statute. And a case of first impression. We had all that talk about precedent, how courts look back at precedent to see what other courts did. Well, if there's no precedent, it's a case of first impression. So they'll take cases of first impression, cases that there hasn't been any decision on. So what happens next? What happens if they grant cert? The parties will submit that record from the lower court. They'll each prepare written briefs to present to the court, and they will go and argue their position before the court, which is quite an interesting thing to watch, and it certainly is to hear. You don't get a whole lot of time. You don't get to argue there all day. They give you a time that you can use. It's set by the court, and it varies, usually like 10-15 minutes. They are all, the kind of neat thing is, maybe I'm geeky like that, is it's online. You can go to the Supreme Court and listen to the arguments online, sometimes live and sometimes it's recorded after the fact. If there are interesting questions regarding copyrights, I may have you listen to one. I've been kind of following. I don't think there's one coming coming up. There was one the last time I taught this class. But nonetheless, it's very interesting to hear the parties argue and then try and see how you think the court would decide. So after they hear from the case, they decide the case. And these are the types of opinions that they can author. I'm going to kind of run through them just for you to be aware. You don't need to know them in much detail. I'm just going to give you what they mean and what they are. But when we talk about these kinds of cases, you kind of have to know whether there was like a majority decision or a dissenting decision. And at least when I talk about it, you're going to kind of, oh yeah, I know what that is. Okay? So let's go through these. There's a majority opinion. That's the most common. One justice writes the main opinion, states the reasons, and at least 5 others sign on saying, yeah, we agree. The majority opinion of the court, and that's the best you can get. That's going to give us what the law of the land is. A concurring opinion. This is where a justice who agrees with the outcome of the majority, but for a different reason, or they just want to provide another point of view that's not in the majority. They'll be a part of the majority, but for a different reason. You'll see a concurring opinion. Dissenting opinion. Ruth Bader Ginsburg likes to write these. Dissenting opinions. The opinion written by a judge who totally disagrees with the majority. Plurality opinion. That's an opinion in which you just can't get a majority. They are all over the place. The majority agrees. A majority of them agree on the result, but not the reason for the result. So you don't get a nice, 5-4 or 6-3. It's all over the board. And of course, when that happens, then you don't really know where the law is going to go from there because you don't really have a majority opinion. You might have a decision, but you don't know why you have that decision. Per curiam. This is an unsigned opinion. This basically, the decision is written just as the Supreme Court. This is a Supreme Court decision. We deny such and such because, and then it's stamped Supreme Court. There's no justice on it. And a memorandum order. This is where the court announces their vote or decision without giving an opinion. They'll just, in People versus Smith, denied. There's nothing else there, and it's given as the court, not as the Supreme Court, not individual justices. So that's the way that they can rule with their decisions. What happens? What do you think happens if there is a tie? Can there ever be a tie? Can there be a tie in the Supreme Court? We have 9 justices, like I said. Can there ever be a tie? There could be if one of the judges recuses themselves. Right now, there's a request from the parties for a case that's in front of the Supreme Court that Brett Kavanaugh, Donald Trump's recent appointment, recuse himself on a civil case involving a party where he has personal dealings with. So if he's off, then there's only 8. So technically, there can be a tie. Or what if one of them dies and they haven't appointed somebody yet? So what happens if there's a tie? What do you think happens? The Supreme Court, the decision in the lower court will be the decision of the Supreme Court. They're affirming what the decision is of the lower court. So if there is an appeal on a serious issue like restricting guns, that's a big issue that has not made its way to the Supreme Court. It almost did, except there was only 8 justices before there was an appointment. Before the Donald Trump election, or the election where Donald Trump became president, we had that. There was only 8 justices, and New York, Connecticut, and Vermont had passed really strict gun laws in the event because of as a result of Sandy Hook in Connecticut, the school shooting. And there was lawsuits brought by the NRA and other Second Amendment rights groups. and the circuit courts in each state, the lower courts affirmed that the laws were constitutional. And then our Second Circuit, which is the federal court in New York State, said it was constitutional, the laws that were passed. And the NRA and that group had to decide whether or not they were going to ask the Supreme Court to review it. There would have been a very good chance of them taking the case because there's no law on the issue. It would have been a case of first impression, but they did not want a tie. And they would have, I would be surprised if it wasn't a tie. They had 4 conservative judges and 4 liberal judges on the bench. So as of right now, the group passed on asking the Supreme Court to hear the case. So right now it's constitutional in the Second Circuit area to have restricted gun laws, but that doesn't mean that applies elsewhere in the country until the Supreme Court hears the case. But had they heard the case and decided it in a tie, and it split as a tie, that would have become the law in the land, that it's okay to restrict guns. It's not unconstitutional to pass laws restricting gun use. So that's how serious it would be if there was a tie. The court's vote is not final until they announce it on their decision day, so it can be changed right up until that time. They're really careful about what they hear. Like I said, they really choose, things of high importance. They won't take any trivial matter. Let's talk about lawsuits. Okay? We talked about our court system. Let's talk about the different kinds of cases. Lawsuits that can be brought, civil lawsuits, that's primarily what we are going to talk about. That's what copyrights are. But there is criminal prosecution type lawsuits, and you can, like I said, you can be prosecuted for copyright infringement. A person can be prosecuted. Civil lawsuits, we have a plaintiff and we have a defendant. Plaintiff is the one that brings the lawsuit. The defendant is the one being sued. The plaintiff will pick out the court that they will hear the case. It has to be a lower court, right? That's where it all starts. And they do this by filing something called a complaint. It's also called a pleading. And you're stating why you are bringing this case. Defendant invaded. I haven't that example. Defendant invaded my privacy. It should be the defendant is using my work of art without permission, is engaging in copyright infringement and trademark infringement, is using a mark that I own, like it could be an ownership. It's I own it. No, you don't. I own it. Could be an ownership question. If there was 2 people who created it, who's the owner? So you have to bring your complaint to the court and say why you're bringing the claim, and then you have to say what you want. Do you want money? Do you owe me millions of dollars? Or do you want stop using my song? You have to say what you want. You can also say I want to stop using my song, but since you use my song, you got to pay me for it. So you can get money and the stopping. So then what happens? That's it. Well, the defendant has to find out, right? So you have to have the defendant served with a complaint, and they're given time to respond. Once the defendant responds, the court will hold some sort of conference, settle, can this thing settle, or let's schedule our dates out. This is when things have to be done by, and we'll have a trial date on such and such a date. So if things don't work out, there's no agreement reached, there will be a trial. And at trial, the plaintiff has to prove by a preponderance of the evidence. That's kind of more likely than not. There's like a little, let's pretend I got my hands up like a scale, one on each side. And you tip the scale just slightly, one way or the other up. You just need a slight little tick up. Think of it as 49-51%. That's how much proof the plaintiff has to put on. And if the plaintiff wins, the defendant is found liable. Now, the defendant gets an opportunity to present their case after the plaintiff's done. After the plaintiff's done and they've tipped the scale in their favor, the defendant can put on evidence to tip it back, and then a little higher in their favor, 51-49 the other direction. And if that's the case, the defendant is found not liable. Don't use the word guilty. This is not a criminal case. That's a criminal case. So it's not liable or it's liable. If you're not entitled to have a jury at a civil case, there is absolutely no right to a jury. Usually they're heard by a judge, or bench trial is what it's called. But you can have one. You have to pay for it, hundreds of dollars to get a jury. And if you have a jury, the verdict has to be a majority. You don't need unanimous, just a majority of the jury in your favor. Okay? And the not so happy party can appeal. Actually, both parties could appeal. Let's say the plaintiff wins. Defendant's not happy about that, so the defendant's going to appeal. But the jury awards the plaintiff, let's say $1 million, and the plaintiff wanted $5 million. The plaintiff can appeal that, the damages amount. So either party who's not happy can actually appeal the outcome, but normally it's the loser altogether who would appeal. And then a criminal prosecution. These are cases that are brought by the government. So if you see a case title that says State versus name, New York versus Jones, California versus Smith, that's a government case, and that's a state prosecution. If you see U.S. versus Jones or Jones versus U.S., that's an appeal involving a criminal prosecution on the names. That's the government. That should ring a bell as it's a criminal prosecution. The individual is given charges, right, by the police. They come and get you. That's how you know you're going to get arrested. You get charged. You get picked up. You get brought to a court where you're arraigned, meaning you're read your rights by a judge. You have the right to remain silent. You have the right to counsel. You have the right to a trial. You have the right to be prosecuted beyond a reasonable doubt. There's a whole bunch of rights that are read to an individual at arraignment. And then the court schedules a conference, and if things can't resolve by the time the trial date that the court sets happens, there will be a trial, and the government has to prove in a criminal case beyond a reasonable doubt. Back to the burden of proof. Preponderance of the evidence, think of it as 51-49 in a civil case. Beyond a reasonable doubt, it's more like 99.9%. It's like way up there. It's not absolute doubt, but it's beyond any reasonable doubt. That's what the government has to prove. The defendant does not have to prove themselves innocent. They do not even have to take the stand because they have the right to remain silent. All the burden's on the government. And the jury verdict, which you're entitled to, a jury. You're entitled to a jury under the Constitution in a criminal prosecution. And the verdict must be unanimous. None of this majority stuff. And then it's the judge who imposes some sort of punishment or sentence. It's the jury who will award money to the plaintiff in a civil case. So that is our overview of the of the American legal system. We covered the state system, the federal system, the United States Supreme Court, and the differences in the two lawsuits. So got to keep those things in mind, because this legal system, this is how we are going to talk about copyright law. We're going to talk about laws, and we're going to talk about court cases.